Over to you, Priyanka.
Oh. Good evening, everyone. On behalf of CASA and our founder CA Sumit Kansal, I welcome you all to the final session of the refresher course on corporate law. Over the past 1 week, from 24th to 30th November, we have journeyed through a rich spectrum of corporate law topics led by eminent faculties and domain experts. Your consistent participation has made this knowledge series truly meaningful. Today marks the final session of the course, focusing on two highly practical and extremely relevant topics: auditors, appointment and removal, resignation, and professional misconduct. Second one being penalties and compounding of corporate criminal cases under Companies Act 2013. Before we begin, it is my honor to once again acknowledge the visionary behind this entire initiative, CA Sumit Kansal, founder CASA. Sumit sir is a fellow member of ICAI with over 18 years of professional experience, has been a strong advocate of continuous professional learning. Under his inspiring leadership, CASA, established in 2010, has consistently worked towards the upliftment of the CA fraternity through powerful knowledge platforms including webinars, seminars, technical sessions, and professional networking. With utmost respect and gratitude, I now invite Sumit sir for his concluding message to the audience as we celebrate the successful completion of this knowledge series. Sumit sir.
Thank you, Priyanka, for wonderful opening remark. And a special thanks to Sumit Kansal ji for accepting the invitation. After we have designed this 6 day series, then we have inserted one more day. Sumit Kansal ji is going to take today's session. So thank you very much. And Manish ji rightly pointed out that today India-Africa match is going on where India is doing the betting. So many one are watching the match, but no worry. कहते हैं ना जो आया है वो डेफिनेटली कुछ पाएगा और कुछ सीख कर ही यहाँ से जाएगा. We have definitely enjoyed the 7 days this series and where we have learned so many topics by the eminent expert from the different industry. After that, also we are planning another GST webinar on the 4th December on at 4 p.m. on GSTR 9C, so you can enjoy the session. And many members are member of this CASA lifetime membership, so definitely you will get the link for enjoying the session, virtual sessions, and we are also planned in the past various physical initiatives like Rashtrapati Bhavan visit. Today we have had walkathon at the North Delhi. Earlier also we have planned Dev Deepavali Utsav, spiritual get together. So many programs we have planned Delhi NCR. So everyone must need to join. And definitely we are also planning for future also. So whatever you have suggestion you can share to me on any topic you want to learn about the learning series or physical program. We are always doing the welcome for any participant for coming forward for a suggestion or anything. Now, this is the final session of this corporate law series. After that, we are thinking to plan a AI course where we can learn the artificial intelligence, how as a finance professional we can use the maximum AI concept for routine practice, in which we can learn Exceling, dashboard preparation, AI use of softwares, writing. So we'll plan and update you in due course. In the meantime, and today's last session, and Sumit ji is going to take on the important topic auditors appointment, resignation, and various other issues. Thereafter, compounding of penalties. So this will also have a great learning experience. Now enjoy the session and any feedback regarding this 7 day series. I think 19-20 participant was regular in attending the session. You can share the feedback by SMS to me. मेरा व्हाट्सएप अभी कुछ टाइम से बैन हुआ है तो आप लोग मुझे मैसेज कर सकते हैं एनी फीडबैक आई विल डेफिनेटली रिवर्ट बैक टू यू माय नंबर आई हैव शेयर्ड माय नंबर इन द चैट बॉक्स so now over to you, Priyanka, for future.
Thank you so much, sir, for
Thank
your
you.
inspiring words and all the initiatives you take. Our speaker for today's session is advocate and chartered accountant, Mr. Sumit Kansal ji, founder of Kansal Law Chambers, New Delhi, and an advocate on record before the Honorable Supreme Court of India. He brings around 15 years of experience and specializes in insolvency and corporate laws, mergers, financial and economic laws, commercial arbitration, and international legal advisory. Mr. Kansal is also a CA, an alumnus of SRCC Delhi, and a gold medalist in LLB from Punjab University. We are delighted to have him with us today. Please welcome Advocate and CA Sumit Kansal ji. Sumit sir.
Thank you very much. Thank you, Team Kasa. And special thanks to Sumit Garg ji and Priyanka Jindal ji for organizing this series. In fact, Sumit ji was very kind. I had actually asked him that we incorporate these topics, and earlier it was meant for 6 days, and then it stretched to 7 days. So 1 week series we had kept. And I'm also thankful much to the participants because for two reasons. Today being a Sunday, I think around 20 people are already there. And it's also a match going off India South Africa, which I came to know today. So there will be two topics today which we will discuss. So पहला जो topic है, I'll talk about the misconduct of the chartered accountants vis-a-vis a narrow topic of the appointment and the resignation slash removal of the auditors. So it's a very important topic. I am myself a practicing lawyer, as Priyanka ji said, and also a chartered accountant. I come across so many cases. I have defended a lot of chartered accountants before the CA Institute also. And the other topic will be regarding the compounding of offences under the Companies Act, the new Companies Act of 2013. तो कुछ तो हमारे ऐसे offences है which are irregularities, technical issues, some minor lapses, some defects which get compounded. However, there are certain criminal nature of offences जो कि fraud है, कुछ falsity है, behind which there is a certain kind of an intent for which there is no compounding allowed. So my associate is also here, Mr. R.N. Gupta. So he'll take further the compounding of the issues once I finish with the professional misconduct matter of the appointment and the appointment of the chartered accountants. So Sumit ji, I'll just share my slide. I have prepared a PPT. तो एक बार मैं वो शेयर कर देता हूँ. Is the PPT visible to all? If they can write it on the chat box.
Yes, sir. The slide says professional misconduct under CA Act, right, sir?
Right, yes.
Yes.
Okay, so as I told, the topic is about the misconduct of the chartered accountants. Now see, the misconduct is given under the CA Act of 1949. जो हमारा CA Act है, I'll come to the preamble, what it says. Uh, the Okay, so it is visible now, I think.
Yes, sir.
Just it is showing, I think, the first slide, no? The second slide. Then how do we go? Just a moment, I'll just. Okay, so now the preamble of the act says that it is an act to make provision for the regulation of the chartered accountants. तो हमारे प्रोफेशन को रेगुलेट करने के लिए एक्ट बना है, and it says that it is expedient to make provision for the regulation of this profession and for that purpose to establish the Institute of the Chartered Accountants of India. तो सर होता क्या है कि there are certain kind of offenses which are enshrined in this act which tantamount to professional misconduct. So basically there is schedule 1 and there is schedule 2. Schedule 1 के offenses है that is majorly internal in nature, meaning thereby that जैसे कि अभी हम डिस्कस करेंगे डिटेल में, एक चार्टर्ड अकाउंटेंट है, he has to seek the approval when he takes up a new assignment from the previous auditor. So it is relating internally, जैसे कि आप profit sharing नहीं कर सकते, you cannot go for ads. So this kind of offenses are tried by a board which is referred to as the Board of Discipline. It's a board which is constituted by 3 members. And then there is schedule 2, which are the offenses which relate to the outside world. जैसे कि आपने कोई ऑडिट रिपोर्ट बनाई, उसमें कोई डिफिकल्टी है, there is certain kind of negligence, there is departure from the due diligence, then it impacts the stakeholders basically. So that is a schedule 2 offense. A schedule 2 का offense है, then it goes, it's more grave in nature, more serious in nature, और ये जाता है disciplinary committee के पास, which is constituted by 5 members. Now there are cases in which there is a certain there are multiple offenses, schedule 1 का भी और schedule 2 का भी है. इस सिनारियो में the matter will again be tried by the disciplinary committee which is of 5 members. So now coming back to this, we talk about what is a disciplinary directorate, which is basically a directorate. It's not a quasi judicial kind of a body. It is to try misconduct which is enshrined under chapter 5 of the act. पहले मैं आपको मिसकंडक्ट के बारे में बता देता हूँ कि ये होता क्या है, किन चीजों पे मिसकंडक्ट माना जाएगा, एंड देन आई रिलेट इट टू द सेक्शंस एंड द क्लॉजेस. So it says, I am reading the important clauses only. Let me know if there is any clarification in between and if there are any questions that could be put on the chat box. So I am reading section 21, subsection 3. Where the director discipline is of the opinion that a member is guilty of any professional or other misconduct mentioned in the first schedule, he shall place the matter before the BOD, as I just told you. और अगर मैटर ऐसा है कि which is mentioned in the second schedule or both the schedules, so it goes to the disciplinary committee which is constituted by 5 members. So this is what the legal framework says. Now मिसकंडक्ट का मतलब क्या होता है, अब हम इस पे जाएंगे कि व्हाट डू यू मीन बाय एक्चुअली मिसकंडक्ट. Professional or other misconduct, this is given under section 22 of the CA Act. It says that it is deemed to include any act, means you do certain kind of an act which is illegal or wrong in the contemplation of the institute of the chartered accountants, or there is an omission provided in any of the schedules. कुछ आपने करना था, you were bound to do, you were legally bound to do something that and there is a departure from that. जैसे कि आपने कुछ ऑडिटिंग स्टैंडर्ड्स नहीं फॉलो करे, या आपने कोई डिपार्चर करा किसी कोड ऑफ एथिक्स से, गाइडलाइन से. बट फर्दर इट सेज दैट नथिंग इन दिस सेक्शन शैल बी कंस्ट्रूड टू लिमिट और एब्रिज इन एनी वे द पावर कन्फर्ड और ड्यूटी कास्ट ऑन द डायरेक्टर डिसिप्लिन. तो डायरेक्टर डिसिप्लिन साहब होती है, जनरली दे आर अगेन चार्टर्ड अकाउंटेंट्स. ही इज नॉट पार्ट ऑफ द कमिटी. I'll tell you how the framework works because these are two important and complex big topics, but the time which we have been given around 45-50 minutes each on these topics. So what happens is कि आपको एक complaint file होती है which can be by a statutory authority or by some company or by a bank or by any private person or even a chartered accountant, but it is always filed obviously against a chartered accountant only. So the complainant can be any person. Now, once this is done, complaint is filed, you file your reply. उसके बाद डायरेक्टर डिसिप्लिन एक पीएफओ बनाता है जिसको बोलते हैं प्राइमा फेसाई ओपिनियन, इन विच ऑन द वेरी नासेंट स्टेज ही गिव्स द चार्जेस कि क्या क्या चार्ज लग रहे हैं अंडर शेड्यूल 1, शेड्यूल 2. After that, the hearing takes place and the matter goes either to the disciplinary committee or the board of discipline, depending upon the kind of clause being invoked, as in which kind of schedule it is falling in. तो बट ये कहता है कि इट मे ऑल्सो गो फर्दर. इट इज नॉट अ वाटर टाइट कंपार्टमेंट कि शेड्यूल 1 या शेड्यूल 2 का ही ऑफेंस होगा. देयर आर केसेस when it is not falling even in schedule 1 and schedule 2, and he has the liberty to even charge you for anything which is not given under schedule 1 or schedule 2. Now coming back further, generally we say what is professional misconduct. So we talk about that it has been explained in different kind of cases. There are case laws about it. It says on the part of a person practicing one of the technical professions cannot fairly or reasonably be found merely on finding of a bare non-performance of a duty. The charge is not one of inefficiency, but of misconduct. So meaning thereby, this somewhere kind of favors us, the chartered accountants, because there are times when we have given an opinion, or there is certain kind of an escape from duly issuing a certificate or auditing the financial statements, or maybe anything which is a kind of an irregularity or a technical defect, uh, procedural kind of a thing. So it is not a case that there is misconduct. Imputation of certain mental condition is always involved. मतलब कि कुछ ना कुछ आपका माइंड में होना चाहिए. There has to be a certain thing. The test is whether in addition to the failure to do the duty, there has also been a failure to act honestly and reasonably. So there could be a case in which you have been tried to be prudent, you have tried to be honest, but still there was something which was not met, which was as per the benchmark, as per the framework, as per the threshold. So you will not be charged for misconduct. Maybe merely a case. There are a lot of cases which I have handled myself, जिसमें negligence हो गई है, ठीक है भाई, procedural lapse हुआ है, no doubt there has been a difficulty, but we cannot tantamount it to misconduct. This is a very celebrated case which I have also enumerated here in this slide, as Ganesan versus AK Jocelyn. So this in this case law, it was talked about this, that what constitutes professional misconduct. Now this is again a very important thing. What happened was, if we go to the criminal law, the general criminal law, which is under the Indian Penal Code, जैसे आप जानते हैं Criminal Procedure Code, Evidence Act है, तो उसमें it says that it has to be, the offense has to be, will be culminated if it is beyond reasonable doubt. Beyond reasonable doubt होना चाहिए, तो वो माना जाएगा. And in the case of civil law, there is certain kind of a probability. So it says the words used is preponderance of probability. अब सीए एक्ट में चार्ज करने के लिए किसी चार्टर्ड अकाउंटेंट को, समझिए बीच की बात है. इट्स नॉट अ केस ऑफ अ सिविल लॉ, नॉट एज लेस सिवियर एज दैट, एंड नॉट एज एक्सट्रीम और ग्रेव एज क्रिमिनल लॉ. It is, the standard is in between. So what it says, this is a judgment of 2019 of the ICI versus Shri Subhajit Sahu. The court had stated that mere carelessness, imprudence, or a grave error of judgment may not always amount to gross negligence. कई बार हम कोई ओपिनियन करते हैं, कई बार कोई ओपिनियन इशू करिए, आपने कोई सर्टिफिकेट दिया, सो देयर कुड बी अ डिफरेंस इन ओपिनियन, or there could be an error of judgment which will not amount to misconduct. But it says where the profession does not apply his mind diligently, fails to exercise reasonable care and caution, especially related to certain kind of documents, that amounts to professional misconduct. So important point is the standard of proof. It says the court clarified that in disciplinary proceedings under the CA Act, the standard required is balance higher than the balance of probabilities, which is under the civil law, but it is lower than beyond reasonable doubt, which is under the ambit of the criminal law. तो इस केस में क्या हुआ कि इसमें जो सी इंस्टीट्यूट ने इनको चार्ज किया था, when the matter went in appeal before the court, so they modified the punishment which was recommended by ICI, और जो removal suspension करा था one year का, so the court directed a severe reprimand only, without putting any kind of an issue on his license, or on without charging any kind of a penalty or a fine. Okay, now so this is very important now. Now अब हम ये बात करते हैं, देखिए समझिए ध्यान से क्या होता है. सर ऑफेंस भी कमिट हो गया, मिसकंडक्ट तो था, अगर मिसकंडक्ट नहीं था तो बच जाएगा, ठीक है, नेग्लिजेंस था, कुछ ना कुछ प्रोसीजरल लैप्स था, इशू था, निकल जाएगा टेक्निकलिटीज पे. लेकिन ऑफेंस तो कमिट हो गया. Now there are two more things to safeguard a person. See, one is that either you go to the law, which is the enshrined law, or you go to the precedents, the judgments. The aspect is that there is sometimes procedural or the technical defects in the filing of the complaint. So this CA Act 1949, very importantly, has to be read. We see a lot of laymen who file complaints. Clients come to me also, and they read the CA Act devoid of these rules. These rules are very important. So rule 3, 4 जो important rules hai, I've given a reference of those. So there is a certain procedure to file the complaint, which is written in rule 3. It says that there is a certain form I in which the complaint has to be filed. We have seen cases in the practical life that a normal kind of a complaint was filed without any prescribed performer, and they had to file a revised complaint in form I. Now, once the complaint is proper and the requisite fee is attached to Rule 5, it gets registered. There are cases in which once the complaint is filed, supposedly there is certain kind of a fee issue which the company has not been paying to the previous auditor. It was an undisputed fee, and the fee is paid. Then the complaint gets withdrawn. Also, there is a withdrawal of complaint under Rule 6. Rule 7 information says what happens is that you don't file it in Form I. This is generally happens from ROC or GST or income tax filing against a chartered accountant. So you have the liberty that still it gets filed, but it will not be considered to be a complaint. It will be called as information. Now, difference of the complaint or information. The first is that the complainant he's not a complainant now. He will be called an informant. The informant will not be allowed to participate in the proceedings before the CA Institute. Hearings may he cannot participate. Number two is that he will not be given any intimation about the proceedings going on. And number three is the cases generally take, this is in fact written in the rules itself, takes a little longer for the disposal. So these things have to be followed. Now I'll tell you what are the loopholes here. The loophole is that, see, what happens is when it goes before the CA Institute, the CA Institute is not a court, not a high court or a Supreme Court, right? So unlike an appeal or a writ or a special leave petition which you file before the higher constitutional courts, उसमें there is a procedure for admission. अगर उनको केस ठीक लगेगा तभी वो नोटिस इशू करेंगे, तभी वो समन्स करेंगे, और उनको लगेगा केस में जान नहीं है तो वही डिसमिस हो जाएगा. लेकिन यहाँ पे ऐसा नहीं होता. यहाँ पे जब कंप्लेंट फाइल होती है, और ऐसा क्यों नहीं होता? बिकॉज दिस इज नॉट अ कोर्ट, इट्स अ क्यूजाई जुडिशियल फोरम. It's an administrative quasi-judicial forum in which you will be asked to file your reply once the complaint is there. Even though the complaint may be frivolous in nature, it could be malicious. But what you need to do is you will have to file your reply. अब अगर आप कंप्लेंट देखेंगे, there are a lot of cases in which there is no board resolution attached. It's filed by a director of a company. बोर्ड रेजोल्यूशन, बोर्ड ऑथराइजेशन तो उन्होंने लगाया ही नहीं है. बैंक से फाइल हुई है, रजिस्ट्रार ऑफ कंपनी से फाइल हुई है, इनकम टैक्स से हुई है. सो दे नीड द प्रॉपर ऑथराइजेशन. That authorization has to be for that particular person, that name of a person or designation of that person who's filing that complaint. उसके बाद कई बार complaint is not properly stamped. Many cases we have seen in the complaint, they do not give details about the allegations under the Schedule 1 or the Schedule 2. So these kind of things happen. Then there are cases in which the prima facie opinion with due regard is prepared by the director discipline. लेकिन अब उसमें जो जो आपको चार्ज करे, that is very different what is stated in the complaint. It's not a part of the complaint, लेकिन PFO में आपको कहीं और चार्ज कर दिया है. So once you defend your case before the institute, even though you might have been guilty, I say, there could be cases in which it is a difference between the complaint and the PFO. Another thing is that you have taken due acceptance from the previous auditor, और कंपनी का कुछ पैसा जो ऑडिटर को है वो देना था. So the auditor, the previous auditor, the complainant comes to for the fact कि उसकी audit fee नहीं pay हुई जी. So this is not the job of the respondent incoming auditor. It is the job of the company. And for that, it is not meant, as I told you, the preamble says it's a CA institute to regulate the profession of chartered accountants. It is not a recovery mechanism here. For that, you go to the civil court. So these are the certain kind of things which are there. And then most importantly, we find, if we read in consonance with the Indian Evidence Act, complaint तो file कर दी, अब proper documents ही नहीं है. The burden of proof is upon him or her who is filing the complaint, they have to show that the case is made out. So it goes in this way. Now, once the order comes from the board of discipline or the disciplinary committee, then it goes, I'll just show you here. Then it goes before the appellate authority. Now this appellate authority is in sector 62 Noida, एंड जो ये डायरेक्टर डिसिप्लिन के पास पीएफओ बनता है उसके बाद जो हियरिंग्स होती है, दीज वर अर्लियर हैपनिंग एट आईपीओ न्यू दिल्ली. नाउ दे आर इन नोएडा. नाउ द ऑफिस हैज शिफ्टेड इन नोएडा. आई थिंक इट इज इन सेक्टर 1 if I'm not wrong. तो अभी recently it has shifted for the proceedings which happen before the ICI. Now once that order comes, so then the respondent chartered accountant has the option to file an appeal. That appeal is to the authority which is in sector 62 Noida, and it says thus: any member of the institute aggrieved by any order of the board of discipline or the disciplinary committee imposing on him any of the penalties referred to in 21A subsection 3 and 21B subsection 3. 21A कौन सा हो गया? बोर्ड ऑफ डिसिप्लिन हो गया. इसके सबसेक्शन 3 में कुछ पनिशमेंट्स है, वो आप पढ़ लेना. 21B डिसिप्लिनरी कमेटी होगी, इसके अंडर भी कुछ पनिशमेंट्स है सबसेक्शन 3 में. So he is aggrieved that he is imposed a penalty. Any member of institute तो ठीक है. अगर कोई चार्टर्ड अकाउंटेंट है जो कंप्लेनेंट है, उसके लिए मैकेनिज्म नहीं है, because it says that imposing on him, the penalty is imposed on the defendant only, on the respondent only, right? So if a chartered accountant's complainant's case gets dismissed, then the remedy is only under writ under Article 226 before the jurisdictional high court. Provided that the director discipline may also appeal against the decision of the board of discipline or the disciplinary committee if so authorized by the council within 90 days. So director discipline को भी option दे दिया. Further, that the authority may entertain any such appeal after the expiry if it is satisfied that there is a sufficient cause. So there is a condonation of delay application which we file along with the appeal which we file before the appellate authority, and it has to be. It cannot be a mere application. So you have to give proper, it has to be reasoned. You have to give the reasons that why there was a delay and how you are condoning that delay because of these so and so reasons. Okay, so now part 1 of the first schedule to the CA Act, in which we talk that there are 12 clauses containing acts or omissions which may make CA in practice to be guilty. So there are another part which talks about a CA who is in service, who is not into practice. Part 1 of the first schedule relates to a CA who is in practice, and clause 8 talks about the fact that you have to take permission from the, you have to inform the previous auditor. So it says, a chartered accountant in practice shall be deemed to be guilty of professional misconduct if he accepts a position as auditor. So he is an incoming auditor, previously held by another chartered accountant, so he was the outgoing auditor, or a certified auditor who has been issued certificate without first communicating with him in writing. So you have to communicate with him in writing. I'll just show you a real case law which I am handling in my office also, which obviously is a bit confidential, in which he had taken the permission, he has ascertained, but he has not received the NOC. This is a very important aspect. NOC तो उनको नहीं मिला, लेकिन उन्हें communication in writing कर दिया था. Now, sir, question ये आता है, can we wait indefinitely? So no. When you are seeking the NOC, when you are giving him the intimation that, see, I am being appointed, this is my appointment letter, this is my ADT1, and this is to inform you that I am being appointed. So you give a timeline or a certain framework that it is 15 days or 30 days in which I would want the NOC. So a judgment, important judgment of the Delhi High Court is there, of Justice Bakru, which says that even though the NOC is not sought, the company will not suffer. Then you can take up the assignment. It is only your duty to communicate with them. अगर आप communication writing में नहीं करते, then there is obviously a default. So that the code of ethics also says that you have to make a communication in writing. That is important first and foremost. You may not receive the NOC from the outgoing chartered accountant. Now clause 9 says a chartered accountant in practice shall be deemed to be guilty of misconduct if he accepts an appointment as auditor without first ascertaining कि requirement section 225 की fulfill होगी. This is written in the act, in the schedule. I have stated it in connect with the New Companies Act of 2013, which is section 139 primarily and section 140. So this is majorly an aspect which is to be dealt by the company, the private limited company. उनको देखना है कि सारी जो भी कंडीशंस है, फॉर्मेलिटीज है, परमिशंस है, आपको कोई स्पेशल रेजोल्यूशन पास करना है, बोर्ड ऑफ डायरेक्टर्स की अप्रूवल है, कोई कैजुअल वैकेंसी है, उस तरह की सारी चीजें, all those conditions have been met. So this has to be duly checked by the incoming chartered accountant. So two things are there under clause 8. He has to seek, he has to uh, give the acknowledgement to the previous chartered accountant, and under clause 9 he has to see that his appointment is not irregular, meaning thereby that all the conditions of the previous chartered accountant have been fulfilled by the company. So now we come to what is it, what the law says under section 139. I have just summarized it so that considering the time constraints and everything. So we say that every company must appoint a statutory auditor at the first AGM for a 5-year term. 5 साल के लिए अपॉइंट करते हैं, लेकिन जो फर्स्ट ऑडिटर अपॉइंट होता है, he has to be appointed within 30 days of incorporation of the company. But if the board fails, then members are to appoint within a period of 90 days. The auditor must satisfy all the conditions under section 141 of the Companies Act. The eligibility conditions are written, and the rotation of auditors is mandatory for listed companies. अगर इंडिविजुअल होगा तो 5 साल है, और अगर फर्म होगी तो 5-5 साल के 2 टेन्योर से 10 साल है. And now what 140 says is an auditor may be removed before the expiry of the term only by passing a special resolution and obtaining the prior approval of the central government. So under the Ministry of Corporate Affairs, you have the ministry, you have a regional director. So there are 5 regional directors in India. You have RD North, and below that you have the respective ROCs and the office of the official liquidator. So ये prior approval आपको लेनी पड़ेगी RD से. When an auditor resigns, he must file a statement with the company and ROC within 30 days. So अगर तो removal का केस है, उसमें 82 फाइल होगा, और अगर resignation का केस है, then it will be a case of 83. So these are certain kind of forms which are given under the Companies Act framework. And they say further that the casual vacancy due to rejection must be filled by the board, and a new auditor can't be appointed unless the outgoing auditor is given a fair opportunity to be heard. Tribunal may order change of the auditor if there are certain reasons or compelling circumstances of a certain kind of a fraud. So if that is the case, today only, in fact, in the morning, even though it was a Sunday, I got a call in which ADT 4 was being filed. So ADT 4 talks about that there is certain kind of fund which is being transferred, which is more than 1 CR. It was my client's case. He was the director in the private limited company, and they are being called now to give reasons. So it says that if the auditor acted fraudulently, so they had talked about this, they have given the intimation in the ROC about this through the ADT 4, the form ADT 4. Is there any question they are asking? He's asking me. Okay, so this is a question also which I think Manoj is asking. He's saying that if you can give some examples. So right. So now this is a real example. I'll just I think it is visible. I just request you please not to click any photos because this is an actual case which I'm dealing in my office. Okay, so this talks about a complaint, and if you clearly see that it is Schedule 1, so this is the complaint which is filed against a chartered accountant, and it says clause 8 तो मैंने आपको बता ही दिया क्या होता है, और description of events है, they sent an email on 15th requesting complainant for an NOC and closing his letter so and so. The company sent appointment letter and resolution without waiting for NOC signed the financial statements. So I again reiterate the fact that NOC लेना कोई हमारी जिम्मेदारी नहीं है, हमारी कोई ऐसी रिस्पॉन्सिबिलिटी अकाउंटेबिलिटी नहीं है, हमें तो कम्युनिकेट करना है. We sent again an email on 21st of February to ascertain about any other document. Charge new auditor has not sent communication by registered speed post and has not waited for NOC. इसमें शायद कम्युनिकेशन उन्होंने करा भी नहीं था, लेकिन किसी केस में अगर कम्युनिकेशन कराओ, we can just show you by High Court judgment also. So in that case, you won't wait for the NOC. Coming further, he was also charged for clause 9. I'll just show you where it is. Now it says that accepts an appointment as an auditor without. I said that there are certain kind of conditions which need to be fulfilled. तो अगर आप इसको देखेंगे, in this the description says incoming auditor should verify the records of the company in respect of the following matters: whether a member of the company has given special notice of resolution as required at least 14 days before the date of the AGM, whether this special notice has been sent to all the members. अब ये ड्यूटी किसकी है सर? This is not the duty of the incoming auditor or the outgoing auditor. It is the responsibility of the company. But हमारी क्या responsibility है? As we are becoming an incoming auditor, we have to check whether all these conditions compliances have been done, which are being written here as 5. So further it says in serial number 4 I'm reading, the complainant has been appointed as statutory audit up to this period. The new auditor ignored the relevant provisions of the Companies as existing auditor can be removed by submitting by AD2 before the term. So all these conditions were a precondition which had to be met. Now, as I just discussed with you, friends, I'll come to that case law, which is SSAY and Associates versus the ICI. It was a writ petition which was filed before the Delhi High Court. So the Delhi High Court upheld the ICI Board of Discipline's finding that KNA Associates committed no professional misconduct. अब इस केस में हुआ क्या था? The petitioner was a firm which was an outgoing firm, but immediately before that, it was not the auditing firm. If you read in this bullet point 3, records filed with the ROC showed that Messrs. Manu Sharma and Company audited the 3 years preceding KNA's appointment. So hence KNA rightly communicated only with them. So KNA was the incoming auditor, outgoing Manu Sharma थे. So they said कि जो petitioner का grievance है कि that they were not communicated and he did not seek the NOC. So that was the Board of Discipline was right. So even though the petitioner approached by way of the writ petition, but the Delhi High Court upheld the ICI's Board of Discipline finding that KNA Associates committed no professional misconduct, as the petitioner firm was not the previous auditor of Tracon International Limited TIL, having ceased to hold the office for the financial year 2005-2006. The court held that Clause 8 of Part 1, first schedule to the Act, only mandates communication with the previous auditor, not an NOC, rendering the petitioner's premise legally untenable. तो उन्होंने जो प्रेमाइज रखा था कि हमसे एनओसी तो लिया ही नहीं, आपने नहीं दिया, मैंने तो आपसे रिटर्न में कम्युनिकेशन ले लिया और आपसे तो इस केस में लेना भी नहीं था क्योंकि you were not that time the immediate outgoing auditor. So they say records filed with the ROC showed that Messrs. Manu Sharma and Company audited the 3 years preceding KNA's appointment. Hence, KNA rightly communicated only with them. The court found the petitioner's claim incorrect and they dismissed the writ petition with 25,000 cost penalties पे लगाई. So these things become very critical in view of the fact that there can be issues which are factual in nature, जबकि केस बनता ही नहीं है. Even though the case is made out, there may be technical, procedural kind of faults, irregularities coming in between, as I just told you, कि complaint proper नहीं है. Complaint अगर proper है तो उसके बाद जो grievance है या जो उन्होंने complaint का जो crux है, that is materially departed when enumerated in the PFO. Then after the PFO, the hearing takes place. हुआ क्या कि hearing हो गई. It was a bench. You know the council keeps changing after every year. And what happened now was the order, the disciplinary order, is passed by a different bench, not the bench who heard your case. So that again is a kind of it is problematic. So the bench, the jury who hear your case have to pass the disciplinary order. Now, even though the disciplinary order is passed, interestingly, and you are charged guilty, after that also you are given still one more chance in which you are to absolve you for the fact कि देखिए 3 तरह की punishments होती है broadly speaking under the Board of Discipline and the discipline committee. One is that there is suspension of your license, which can be for few months to several years. There is certain kind of a penalty which is levied, 1 लाख 5 लाख इस तरह से लिखा हुआ है एक्ट में. And then there is reprimand. Reprimand means that there will be a kind of a, जैसे आपको डांट लगेगी in very crude terms speaking, it will be a kind of a caution, kind of a reminder for you, but will not bring any kind of a dent on your license, and there will be no penalty, obviously. So what happens is that after the punishment order, after the disciplinary order is passed, we have given kind of submissions in which the CA was only reprimanded, because issues come with the fact कि जब हम empanelment भरते हैं सर, उसमें वो पूछ लेते हैं कि any kind of misconduct matter is running against you, या पहले कभी भी हुआ है, या फर्म के अगेंस्ट पूछ लेते हैं, तो वो नहीं होना चाहिए कि कोई लाइसेंस पे बात आ जाए. तो उसमें we talked about the fact that the CA has an unblemished professional career. The career has been for so many years. There has not been a single instance of misconduct against him. Sometimes the complaint is motivated, it is frivolous in nature. The chartered accountant is made as a scapegoat. So, and we talk that there is a kind of a personal dispute, and the CA out of the way is dragged in between. There are cases in which it's a case of issues going between the directors of a company in the NCLT or in arbitration or in the civil court, और CA इंस्टीट्यूट में वो एक्स्ट्रा डाल देते हैं प्रेशर बिल्ड करने के लिए, only as a matter of a pressure, trying to extort certain kind of money in other forums, so that CA पे भी डाल दो जी इसी इंस्टीट्यूट में. So these kind of things happen. Then there can be circumstances in which the CA made good the default हुआ no doubt, लेकिन कैसे उनको पता चला उन्होंने ठीक कर दिया, that means that intention was not there in the first place. There could be cases in which we showcase that he was reasonable, prudent to the best of his ability, but there was some extenuating circumstances which crept in, which led to this, or it was a case of a minor lapse. So these kind of things go in which a person may be saved eventually. So this is from my end, kind of, because it was a period of almost 45 minutes, 1 hour. And Priyanka ji, are you there?
Yes, sir.
Yeah. So if there is any questions or anything, I'll be happy to take.
Oh,
And then my associate can take the part two of the compounding of offenses.
okay, sir. So, participants, if you have any questions, we request you to please post your questions in the chat box. Sir is here to answer all your questions. As if now, sir, we do not have any questions.
Very well.
So you
So
have
I think my associate can take it forward, है ना, with the part
yes,
to the next topic, and
yes,
I'll also assist in between another around 40-45 minutes we can keep it, and as the questions come in, then we can take it afterwards.
yeah, sure,
I
sir.
think that should be fine.
Yes.
All right, all right. So Mr. R.N.
So
Gupta
there's
is there.
one.
We have one question, sir. We have got one question. So shall
Uh,
we
Yeah,
take
yeah.
it?
Please tell me what is it.
The question is, an auditor was appointed subject to death of existing auditors. Rajesh Gupta ji, what is the question? We are not getting your question. Can you please elaborate? So we have this question, sir. The next question, can the audit firm be appointed for a maximum to consecutive period of 5 years? Any relaxation for private companies?
Yes, the audit firm can be appointed. In fact, I'll just read out as I just told also. We'll go to this section 139, which talks about section 139 is there. It says that no listed company or a company belonging to such class shall appoint or reappoint an audit firm as auditor for more than 2 terms. So the maximum time period is 2 terms, can be appointed for 2 terms if it is a listed company. All right. More than 2 terms is not allowed for a consecutive period.
Okay.
So yes, it can be appointed if it is a listed company. In fact, it's a mandatory requirement as per 139.
So I wanted to ask, this auditor was appointed post the death of the existing auditor, and how do you do the communication process in this case?
So obviously, sir, in this case, it will not be done. It will be a case of kind of a thing which has happened out of the way abnormally. And in fact, this will be this new auditor will have to showcase. He will have to ascertain properly pinpoint that he cannot make a communication with the previous auditor. Okay. So either he seeks the copy of the death certificate or he sends an email to them, whatever it is. It could be a firm of chartered accountants, but he will have to showcase that he is duly aware about this fact. It cannot be
Okay.
a case that a previous auditor has died and you have not communicated, and afterwards you become wiser, stating he had died, so I had not communicated, and you become aware afterwards, right? So you try to communicate. If you are not able to communicate 2 3 times, or you send an email, they are not able to reply, and then as in I just told you, you can make a framework of 30 days or so to seek the NOC. You don't get that, then you can move ahead with that. That's not a difficult.
Fair enough. Thank you so much.
So, Nareshi, please, I'm not able to understand your question properly. So, can you please write it down again, or if you want to talk to sir directly, you can ask for unmuting. So we have this question, another question. One of my client, a private company, pays money to many advocates for certain cases running in various courts, not related to this company, but related to companies in the group, where directors are common but not a subsidiary, but majority shareholder is common. Does it amount to funds diversion, as the amount may go beyond rupees 1 CR from Narang? Uh, this question is from Mr. Narang, I guess.
One of my clients. So, see, as per these limited facts, it appears that these companies are related. It's not a subsidiary, but the companies are related because the directors are common, the shareholders are also common, and the cases are going in various courts. So, I think the sir is asking that, uh, see, if it is beyond 1 crore, it is not mandatory. ऐसा जरूरी नहीं है कि fund diversion होगा. The case of fund diversion has to be made. If it is a case that it tantamounts to fund diversion, it causes any kind of a grievance or it detriment to any of the stakeholders, and the clear-cut evidence is there that funds are being diverted from one company to another, which is related, and it is more than 1 year, obviously, then there is a difficulty. So 2 3 things have to be met out: that the companies are related, the funds are diverted, and it is more than 1 year, which I was just talking about the case today about ADT4.
Hello,
I think, yeah,
hello.
Yes, sir, you are audible. Please continue.
Good evening, sir.
yeah, good evening, Jay.
सर जो सर 14 जुलाई को अमेंडमेंट आई है ना कि अगर आपने कोई भी नई कंपनी इनकॉर्पोरेट की है तो उसमें ADT1 फॉर्म सर भरना मैंडेटरी है नई कंपनी के केस में। सर वो उसके बारे में थोड़ा सा क्लियर कर दो।
सर मैं एक बार इसको भी देख लेता हूँ because I think it's an amendment. So what I'll do is I'll just write to you on the chat box, or I'll just take up this question. In the meanwhile, I think Aryan can take up. I'll just see this amendment. Right? मैं अभी बताता हूँ नरेश जी आपको.
ठीक सर।
I'll just let you know.
Okay, sir. So next question is, if company want, can auditor be appointed for less than 5 years?
So see, the auditor as per the AGM has to be appointed for a period of 5 years. If I go to the section, what my law says is 139(6) says that the first auditor shall be appointed by the board of directors within 30 days from the date of incorporation or the registration of the company. Now, after that first auditor is appointed, then in the annual general meeting, the auditor has to be appointed for a period of 5 years only. Now, if you are appointing that auditor for a period of less than 5 years, then you will have to give the reasons that why are you removing him. That obviously is a removal of the auditor. Now, what are the reasons? What reasons are there? Compelling reasons that you remove him? It cannot be whimsical or on a certain kind of a thing that you remove him before a period of 5 years. The law says 139 subsection 1 says that it has to be for a period of 5 years.
So,
Somebody's written that 5 years is compulsory.
sir, I also have one question. So
Please,
can't we
please.
do like this? Like for 1 year we are filing ADT1, and for another year we can file another ADT1, or because I've seen this thing that one of my client, he appointed for 1 year, and then he renewed the ADT1, this sort of thing. So this also
No,
happened.
see, it might have happened. This, ma'am, again happens on case-to-case basis. Generally speaking, the ADT1, which we have seen, the appointment letter is issued for a period of 5 years. It might be some irregular case that there was some difficulty. I have also seen that ADT1 was filed, the person got removed, there was some difficulty happening, and he again got appointed afterwards with a fresh ADT one. But as such, as a general scenario is that ADT one is for 5 years.
Okay, sir.
Yeah. So I think we can start with the compounding. Priyanka ji?
Sir, we have this question, continued question from Mr. Anaranji. So, in continuation to that earlier question,
The company's cases are, they are not doing any. See, this is actually a particular case in which the documents have to be seen into, perhaps it's not a straight jacket formula. In continuation to my query, this is happening to this company, and the other company's cases are, they are not doing any business. So now, if those other companies, I don't know, Narangji, because the other companies are not doing any business, doesn't mean that they are hollow or the shell companies. They are paper companies. But if that is the case, those companies are made solely for this purpose to route the funds, then obviously it is a case of fund diversion. If they are paper companies, they are shell companies which are made for this purpose only. They are, but if the audit fee is coming, then obviously they are doing some work or some transactions are there. So it has to be seen whether some real business is happening in that company or it is merely a paper company. If it's a paper company, the company which is routing this kind of funds, obviously it's then a case of a fund diversion. So that would be the case, ma'am.
okay, so I guess, sir, we are done with the questions currently we have in our hands. So, shall we move to the next part of the session?
Yes, I think we are good to go with.
Okay.
Mr. R.N. Gupta is there. He is also a licensed practitioner before the Bar Council of Delhi. So he's my associate and he'll take this.
Okay,
Thank
so
you
we
for the
welcome.
kind words. So I hope everybody I'm clearly audible.
Yes, sir, you are.
Yeah, perfect. So thank you for the kind words.
Priyanka ji, I think you are on mute.
Okay, yes, you are very much audible,
Priyanka
sir.
ji, you are actually there.
Am I audible now, sir? Can you hear me? Hello?
So yeah, I can hear you, ma'am.
Okay,
So
on behalf of CASA and Sumit ji, I welcome you, sir.
thank you. Thank you so much for the warm welcome, Priyanka ma'am. And thank you, Sumit sir, for the kind words. As Sumit sir mentioned, I'm a practicing advocate in the leading councils of Delhi, that is the Delhi High Court and the NCLT. Along with him, I assist him in the matters which are related to compounding, which are related to mergers and acquisitions and insolvency before the NCLT and other forums of Delhi. So, since the topic has already been clearly mentioned, that is the compounding of offences under the Companies Act 2013, I will just be sharing my slide now. I hope it is visible. Can anybody please provide a thumbs up? Yeah, perfect.
Yes, sir, it is.
So, as we've talked about that compounding as an offense, there are multiple offenses under the Companies Act 2013 which were revised post the 56 Act. A lot of banter had been around once the act came into promulgation that the penalties and the fines imposed have been increased many folds, which is very well visible in the act that the penalties and the fines go up till 25 lakh rupees as well, and on per day fines as well. So considering this, we had dropped in the rankings for ease of doing business all across the globe. Basically, after observing that, the MCA basically came into the picture and they thought that we should remove or we should at least reduce or give scope to reduce these particular penalties in order to basically have easier of doing business in India. सो प्राइमरीली कंपाउंडिंग को अगर हम समझें, कंपाउंडिंग सिर्फ एक सेटलमेंट मैकेनिज्म है अंडर द कंपनीज एक्ट, जो हम लोग का अप्रूवल होने के बाद बाय द अथॉरिटी विच कैन बी द एनसीएलटी और द आरडी is allowed to pay a lesser fee in comparison or a lesser fine in comparison to what was initially imposed by the section. So, as the PPT clearly states, a settlement mechanism allowing payment of compounding fee to avoid prosecution. As per the Act, the prosecution has been as per the special courts, under the special courts, which are usually the district courts all across the district. And that is a long procedure that invites litigation into the process for the company. Moreover, since the filings can also get, you can say, abridged because of the prosecution and pending non-compliances, the company gets affected. Therefore, compounding comes into the picture as as a savior, I would rather say, and helps people get done with their particular non-compliances in a faster manner. The caveat over here is that compounding is not available for all kinds of offenses under the Act. कंपाउंडिंग गिने चुने दो टाइप के ऑफेंसेस के लिए ही है अंडर द एक्ट, जिसमें या तो सिर्फ फाइन है या फिर फाइन और पेनल्टी और इम्प्रिजनमेंट का ऑप्शन है. अगर किसी ऑफेंस के अंडर अगर किसी पर्टिकुलर नॉन कंप्लायंस ऑफेंस के लिए देयर इज अ पेनल्टी दैट इज ऑफ इम्प्रिजनमेंट ओनली or of a different stature of imprisonment, then in that scenario the offense cannot be compounded. Prosecution remains the only manner in which one can go about. The compounding has only one section under the Act, that is Section 441, as it is visible in the slide. And under that particular thing, the whole procedure for compounding has been enumerated well under the Act. It is exhaustive in nature. There are rules, but there are not any specific separate rules for compounding that have been promulgated by the MCA. So the section in itself is exhaustive in nature. As I earlier talked about the objectives, why compounding came into the picture, as are very well displayed in this particular slide, that it promotes a compliance culture. Usually, we have a tendency कि अगर हम लोग को ऊपर फॉर एग्जाम्पल कोई हमने पेमेंट करनी थी, उसमें लेट फी लग गई, लेट फी के ऊपर इंटरेस्ट लग गया, अब वो फी थी 500 रुपए की, वो करते करते 1500 रुपए पहुंच गई, तो वी टेंड टू बी मोर डिलिंक्विट टुवर्ड्स दैट पर्टिकुलर पेमेंट, because we are having a problem with those extra 1,000 rupees that have been added to the original 500 rupee fine. तो कंपाउंडिंग के बेसिस पे वो 1,500 रुपीज की फी फॉर एग्जाम्पल कैन बी रिड्यूस टू 750 और 600. If that reduction is there, then the chances of the government recovering its dues and the compliance by the company increases. Secondly, it reduces litigation, which is already a big hassle for the country. We have more than 4.5 crore pending cases all across the country in various courts. So that reduces the burden for the NCLT as well as the special courts. Secondly, it allows the company to rectify the technical and procedural defaults in a swifter manner. As I mentioned earlier, बहुत बार ये होता है कि हम कोई नॉन कंप्लायंस करते हैं, जैसे AOC 4 फाइल नहीं हुआ या MGT 14 फाइल नहीं हुआ, तो विंडो एक पॉइंट ऑफ टाइम के बाद क्लोज होने का चांस रहता है, दैट द MCA और द पोर्टल डज नॉट अलाउ अस टू प्रोसीड फर्दर विद द compliances. By having compounding of a particular order, that window reopens in a swifter manner in comparison to the prosecution. So, as I mentioned, there are different kinds of punishments under the Companies Act. One is a penalty. Then penalty is, there are people usually misread or interpret it in a similar manner wherein a section mentions penalty or a fine, but there's a difference between the two. The penalty is as an administrative charge that is being put under the act and is regulated by the ROC. अगर एक पेनल्टी लगी हुई है तो वो ROC को पे किया जाएगा, ना कि सेंट्रल गवर्नमेंट को. On the contrary, if there's a fine, that fine is a liability and that is to be adjudicated by prosecution. Once that prosecution is done, then only a fine is payable. So that comes under the garb of RD and the special courts. This particular scenario is compoundable. And thirdly is the imprisonment. Imprisonment, as it states, you go inside for offenses which are serious in nature, just like fraud or falsification of accounts or something of that sort, which is grievous in nature and against the public interest. जिन ऑफेंसेस के लिए सिर्फ इम्प्रिजनमेंट प्रिस्क्राइब्ड है या सिर्फ एक सर्टेन अमाउंट ऑफ इम्प्रिजनमेंट प्रिस्क्राइब्ड है, वो कंपाउंडेबल नहीं है. उनमें ओनली सोल्यूशन दैट इज लेफ्ट is to go to the prosecution, the ROC prosecutes, and you're left to the mercy of the special courts or the NCLT. So this statutory provision is divided, Section 441, into two sects. One is compoundability by the RD, another is compoundability by the NCLT. These are the two only authorities under which compounding can be done, only for those offenses wherein there is just a fine or there is just a fine or there is penalty or imprisonment prescribed. अब इसमें पहले 2020 से पहले जब कंपनीज एक्ट का अमेंडमेंट नहीं हुआ था, तो तो जो आरडी का थ्रेशोल्ड था वो बहुत कम था, लेकिन 2013 के एक्ट के अंडर पेनल्टीज इतनी बढ़ चुकी थी कि 5 लाख की पेनल्टी बहुत इजीली कोई भी एक्सीड कर जाता था. So therefore, in 2020, the act was amended, wherein the jurisdiction for the RD in a pecuniary manner was increased from 5 lakh rupees to 25 lakh rupees. So as on date, the law stands that wherein there is an offense whose maximum amount of penalty, I would emphasize on maximum because the penalty prescribed is of various natures and on day-to-day basis as well. So this is the role of the officer of the company or for the compliance agents like us to calculate कि हमारी maximum penalty कितनी निकल के आ रही है as per the days as well. If that is under 25 lakh, we can approach the RD for the particular compounding of the offense. Otherwise, if it's gone above 25 lakh rupees, the only option left is the NCLT. So there are certain criterias for compoundability. First one being that offenses are usually procedural technical in nature. जब 2020 में अमेंडमेंट भी आया तो एमसीए ने इन चीजों पे देखा जो डिफॉल्ट्स प्रोसीजरल और टेक्निकल होते हैं नेचर में, जो कोई जान पूछ के नहीं करता, एज इट गोज इन द सेंस ऑफ द लीगल लैंग्वेज दैट इज मेंसरी इज नॉट इन्वॉल्व, or to intend to defraud the public or the government is not involved. Those offenses are kept in the category of compoundable offenses. Secondly, reinstating that imprisonment is not mandatory. Or का clause होता है fine or imprisonment. If it is only imprisonment, then sorry, there's no chance of anyway getting the offense compounded. Thirdly, no fraud or intent to deceive exists. The section 447, 448, and 449 of the Companies Act, which talks about a fraud, which talks about falsification, which talks about concealment of evidence and falsification of evidence. These are offenses which involve a mens rea in itself. मतलब हमारा इंटेंट होता है डिसीव करने का, चाहे पब्लिक हो चाहे गवर्नमेंट हो. अगर वो एग्जिस्ट करता है इस पर्टिकुलर किसी भी ऑफेंस के केस में, तो वो ऑफेंस कंपाउंडेबल नहीं रहेगा. Thirdly, the category comes. This is an important one. बहुत बार क्या होता है कि हम लोग अलग अलग एप्लीकेशंस फाइल करते हैं फॉर अ सिमिलर काइंड ऑफ एन ऑफेंस. जैसे एक कंपनी ने एनुअल रिटर्न्स नहीं फाइल करी, उसने 2017-18 के फाइनेंशियल ईयर में भी नहीं करी, 18-19 में भी नहीं करी और 19-20 में भी नहीं करी. तो इसके लिए देयर विल बी ओनली वन एप्लीकेशन दैट विल बी फाइल्ड. If we file three different applications, then only one shall be allowed, because the law, that is the section 441, clearly states that no repeat offenses within the prescribed time limit is allowed, that is of 3 years. तो अगर आपने एक ऑफेंस कंपाउंड करवाया है जिसका टाइम लिमिट प्रिस्क्राइब 3, जिसका टाइम लिमिट फॉर एग्जांपल था यू डिड नॉट फाइल द एनुअल रिटर्न और द एओसी 4 फॉर अ पर्टिकुलर फाइनेंशियल ईयर फॉर अ कंपनी, then within a span of 3 years from the compounding order, you cannot file another application for compounding the same offense. So this is something that is prescribed. इस scenario में the only solution left for you is to go for a prosecution. अगर आपसे default हुआ 20-21 में, आपने उसको कंपाउंड करा दिया, कंपाउंडिंग ऑर्डर आ गया और 21-22 में आपसे वो डिफॉल्ट फिर हो गया, तो आप कंपाउंडिंग पे नहीं जा सकते, आपको प्रोसिक्यूशन में ही जाना पड़ेगा. दैट इज यू नीड टू अप्रोच द स्पेशल कोर्ट और द एनसीएलटी. So these are certain examples for the offenses that are compoundable in nature under the Act. I'll highlight the important ones, otherwise all of them are on your display. You can have a read. Section 92, that is the annual return, non or late filing of annual return. One of very common compoundable offenses that we come across on daily basis. Secondly is punishment for omission to conduct AGM, section 99. अब इसके अंदर भी बहुत बार होता है जो कंपनीज यूजुअली डोमेंट होती हैं या डायरेक्टर्स मल्टीपल कंपनीज में होते हैं, क्लोजली नेट कंपनीज होती हैं, वहां पे देयर इज ऑफन अ चांस दैट एजीएम्स आर स्किप्ड. दैट इज देयर. देन कम्स this section 134, board reports as financial statement non disclosure violations. They are often prescribed formats जिसके अंदर कभी कभी अगर डिटेल्स पूरी ना हो तो कम चीजों के साथ फाइल कर दिया जाती है चीज. If that is there, then that is again a problem that is yet again compoundable in nature. Then comes section 140 subsection 3, as sir had taken the previous session wherein we were talking about appointment and removal of auditor. So auditor resignation का जो form है, that is also to be filed with the registrar. That is mandatory. If you don't do that, then also it becomes an offense, but that yet again comes under the category of compoundable offenses. Then comes section 147. Then offenses related to auditors and companies. I will also show you a case study. We recently came across one matter wherein in a matter, the financial statements that was filed by the auditor, the difference between the basic and the diluted EPS was not highlighted in the balance sheet. Although उसमें कुछ नहीं था, the diluted and the basic EPS was exactly the same. But still, it was not mentioned in the financial statement, which was taken up by the ROC in the special court, wherein they were about to launch a prosecution against the company. So that particular offense is also compoundable under this particular nature. So these are certain types of examples which are usually compoundable and usually are given the orders. Now, this is the ratio behind compounding. इन ऑफेंसेस की कंपाउंडिंग क्यों अलाउ की गई है, उसके पीछे एक वजह है जो मैंने आपको अभी पिछले स्लाइड में स्टेट किया, सेक्शन 92 एनुअल रिटर्न. दिस इज वन ऑफ द मोस्ट कॉमन डिफॉल्ट्स दैट वी कम अक्रॉस व्हेन सीएस कम टू अस कि सर ये डिफॉल्ट हो चुका है एंड द पेनल्टी इज ऑलरेडी पैरामाउंटेड टू 1.5 लाख रुपीज और 2 लाख रुपीज इन दैट मैनर. सो ये यूजुअली दिस इज अ प्रोसीजरल लैप्स. क्लाइंट ही नहीं उठ के आया, देयर वाज एन अनसर्टेनिटी ऑफ कम्युनिकेशन बिटवीन द क्लाइंट एंड द सीए. अब कभी कभी पता ही नहीं होता कि जी ये क्लाइंट को काम करवाना है या नहीं करवाना है. In that scenario, most of the times the procedural lapses occur. But later on the client comes in कि सर वो तो काम कराना था आपने फाइल नहीं किया. So in that scenario, compounding is taken up. Then comes filing of resolution under section 117 and agreements. One of the most common ones which I have come across is this filing of MGT 14 after passing an SR. कभी कभी क्या होता है कि अनऑफिशियली एक एजीएम होल्ड कर लिया अगर स्मॉल कंपनी है, and then they basically declare the particular things that they need to take the decision of, but the filing is left. In that scenario, it is yet again a commonly compounded offenses which RD and also take a loose note upon. Then comes filing of financial statements with the registrar, that is 137. Yet again a very important one and we come across very often कि late हो गया, delay हो गया. अब इसके अंदर एक caveat है which we professionals can understand. बहुत बार ये होता है कि इनकी वेबसाइट ही नहीं चल रही होती, देयर पोर्टल इज नॉट वर्किंग, एंड दिस इज द मोस्ट कॉमन प्ली दैट वी कम अक्रॉस एज प्रोफेशनल्स कि सर द वेबसाइट वाज नॉट वर्किंग, हाउ कुड आई फाइल्ड इन दैट पर्टिकुलर इंस्टेंस. अब उस सिनारियो में भी यही किया जाता है कि वी गो फॉर अ कंपाउंडिंग एंड द आरडी आल्सो टेक्स अ लाइटर नोट ऑन इट बिकॉज ही आल्सो अंडरस्टैंड हाउ द गवर्नमेंट इंफ्रास्ट्रक्चर ऑपरेट्स. Finally, we go up to the final one, that is section 165, that is number of directorships. A very common thing that happens with closely held companies and family businesses which are operating in a sister concern business, in a sister concern workflow. वहां पे एक डायरेक्टर एक कंपनी में भी है, जैसे फादर भी डायरेक्टर बन गया, बेटा भी डायरेक्टर बन गया, फिर बेटे ने आगे 2 कंपनीज और बना ली, उसमें बेटा भी हो गया और बहू भी डायरेक्टर बन गई. उस तरीके से उसमें अपनी मदर को भी बना लिया. इस क्रॉस नेट के अंदर बहुत बार पता नहीं लगता कि व्हेन यू एक्सीड द डायरेक्टरशिप लिमिट ऑफ 20, in that scenario, this is also one of the offenses that can be compounded. Finally, if one caveat that I missed and that I must emphasize upon is all these offenses highlighted over here are compoundable in nature. But the first and the foremost condition to be fulfilled while getting an offense compounded is that have you made that wrong right? This is the first question that RD also put across as to us when we are in a hearing कि सर जो आपने नॉन कंप्लायंस किया था या जो आपके डायरेक्टर ने मिसफियंस किया था, इज दैट हील्ड, इज दैट क्योर्ड? तो आप किसी भी इस ऑफेंस को अगर कंपाउंड कराने जा रहे हैं, उसमें किसी भी प्रोफेशनल के पास जाने से पहले आप ये अश्योर कीजिए कि ये क्या ऑफेंस आपने फाइलिंग कर दी है या ये फाइलिंग हो गई है या ये बेसिकली आपने इसको रेक्टिफाई कर दिया, बिकॉज आरडी टेक्स अ नोट ऑफ दिस इन द ऑर्डर. I'll show you in the future whatever case studies that I'll be showing you. उन केस स्टडीज में बहुत इजीली आपने देखा नोटिस करोगे कि आरडीए कहा कि जी दिस पर्सन वाज रिप्रेजेंटिंग दिस पार्टी एंड दिस पर्सन स्टेट्स that this particular offense has been made right by filing of this particular thing, white challan so and so, filing of so and so resolution, white challan so and so. So make sure whenever you're getting an offense compounded, you've rectified the wrong that had been committed by the officer in default or by the company. This is the procedure. Now let's come to the procedure of practically how to get an offense compounded. The first and the foremost thing is passing of a board resolution. That is done by us professionals itself. The client comes to us, we need to first prepare a board resolution that we are willing, this default has been done. The company needs to admit that this default has been done, and then it is rectified. that is also to be stated in the resolution, and then a board resolution is to be filed. Secondly, we prepare an application. This is an exhaustive application wherein we attach the annexures of all the evidences that we have rectified the wrong that was committed, what was the reason that this offense was committed, how this company has had a good character, or the officer in default has been very compliant with all the laws of the on the laws which are applicable on the officer in default as well as the company. So this application is exhaustive in nature. Often, this is prepared by the whole. This is prepared by lawyers usually.
तो बेसिकली होता कैसे है? What happens is the case. These are certain kind of offenses which are compoundable in nature. So ROC आपको चिट्ठी लिखती है, आपने उस डिफॉल्ट को you have not made good, then they send you a reminder. Then it happens so that they file a case before the court of law, before the actual courts, which is the court speaking very precisely of the ACMM, Additional Chief Metropolitan Magistrate, under the special acts. We have cases here, which we have done a lot of cases, which cases are filed by the income tax office, which are also filed by the ROC. Talking about the ROC, which my associate Aryan will also now show you. What happens is कि उन्होंने कंप्लेंट बना के डाल दिया आपके अगेंस्ट. तो आपके पास दो ऑप्शन है सर. Either you fight that case. How will you fight that case? ऑफेंस तो हो ही गया, जैसे कि आपको कोई डिले हो गया एजीएम के बीच में, which is infringing your provisions of the Companies Act. या आपने कोई or something was to be done from the company's point of view, which was under section maybe 139 or under 131, or it was a case that the auditor did not have due diligence. Complaint to file hogi ab. So now you have an option, as he is just telling, in the cases which are compoundable offenses, you can file a compounding application under section 441 of the Companies Act 2013. So this application will not talk about obviously the complaint which is filed in the district court, but you will say that see this is what I am, and you will give certain kind of grounds stating कि ऐसा ऐसा offense हुआ था, we have made it good. ये offense पहली बार हुआ था. जैसे अगर हम ऑडिटर की बात करें, कंपनी ने जैसे हमारे केस में कंपाउंडिंग ऑर्डर ले लिया है, तो ऑडिटर को भी मिल जाए और इसमें कोई इम्पैक्ट नहीं पड़ा. ये बहुत इंपॉर्टेंट बात है कि जो हमने ये डिफॉल्ट करा है या कुछ हुआ है, अगर उस केस में ऐसा है कि स्टेक होल्डर्स पे इम्पैक्ट नहीं पड़ा और ये this will not be taken up in future, and it was not a case which was done by dishonesty or any kind of a malafide. It was a lapse which happened because of so and so reasons, and then you put annexures also there. उसका कोई हार्ड एंड फास्ट फॉर्मेट या रूल नहीं है. एक नॉर्मल जैसे आप इंडेक्स बनाते हैं, उसके बाद आप एक कंप्लेंट बना देंगे या पेटिशन बोल सकते हैं उसको, and you put annexures A, B, C, D. You file the power of attorney or the wakalatnama. It can be filed by a chartered accountant. It can also be filed by an advocate or any other professional, not mandatorily a chartered an advocate only. और ये फाइल होगी आपकी jurisdictional ROC में. तो रजिस्ट्रार ऑफ कंपनीज उसको कंसिडर करेगा, चेक करेगा कि प्रॉपर है हर हिसाब से. अगर कुछ उसमें फॉल्टीनेस होगी, देयर इज अ सर्टेन काइंड ऑफ filing procedure which is mandated under the law, and then this ROC will send it to the RD, the regional director. Upon having it from the ROC, this complaint as it is will be sent to the RD with the observations of the ROC. Then the RD will conduct a hearing. So RD is not a court; it's an administrative office. He will conduct the hearing. उन्होंने जो भी penalty law के हिसाब से fine लगाना है वो लगाएंगे. And then you deposit that fine. The challans will be generated. Then the RD will pass the final order. उसमें जो final order आएगा RD साहब का, that order you annex or you show it to the court. Once you show it to the court, filing the RD order with the special court for quashing, तो आपकी वो criminal complaint quash हो जाएगी. Then the case will be get closed in the court of law. So it's basically a three-tier kind of a mechanism in which two departments are involved and the court is involved.
So, Sumit sir has given a very well and a very practical explanation of how this procedure goes. So this is precisely how it goes. Although ये सुनने में बहुत स्विफ्ट लग रहा है कि ये हुआ, फाइलिंग हुई, आगे ऐसे गए, ऑर्डर आया, आपका जो प्रिलिमिनरी ऑर्डर है उसके बेस पे आपने फाइन पे किया, चालान जनरेट किया, आरडी के पास फिर से फाइल किया, फाइनल ऑर्डर आया, वॉशिंग की एप्लीकेशन आपने अगर प्रोसिक्यूशन लॉन्च हो चुका है तो लगा दी. बट दिस इन इटसेल्फ टेक्स अ स्पैन ऑफ समवेयर अराउंड 6 to 9 months, because the ROC in itself has a 90-day limit to send the particular application that you filed for compounding to the RD. और यूजुअली वो सेकेंड महीने के बाद ही पहुंचती है उनके पास, सो 2 महीने आपके यहीं चले जाते हैं. देन आरडी ब्रिंग्स इट अप फॉर हियरिंग. बहुत बार ये होता है, इट इज एन इनफॉर्मल कोर्ट that RD is having a sitting in his own chambers wherein you argue a matter in front of him. Sometimes RD is on some ministry duty or is out for some meeting or somewhere. You get a date. So this in itself takes a time of somewhere around 2 to 3 months. Once you get a preliminary order in your favor of having the particular uh, amount of compounded of penalty that you get, then you pay that. Once you pay that, then you again file it before the RD that this has been paid and a final order will be passed. That yet again takes another time. फाइनली जब आपके पास वो हाथ में ऑर्डर आता है, दैट इज अ ट्रू कॉपी ऑफ इट, दैट इज टू बी फाइल्ड. I think I was muted. Yeah. So that order is finally to be filed and an
Sumit ji,
application
kindly
before
mute
the
yourself so that
ACM.
what
बहुत बार ये होता है कि जब प्रोसिक्यूशन वहां पे चल रही होती है तो द ACMM इज नॉट अवेयर ऑफ द कंपाउंडिंग ऑर्डर, तो वो आपको अगेंस्ट कुछ ऑर्डर ना कर दे. इन द मीनवाइल यू जस्ट शो इट टू हिम फिजिकली व्हाइल यू गो फॉर अ हियरिंग. जैसे कुछ हियरिंग्स में होता है कि वो इतना क्लैश कर जाती है कि आपके अगेंस्ट एक प्रोसिक्यूशन लॉन्च होने ही वाली होती है एट. I think I'm being muted by somebody. Priyanka ma'am, if you can just
नहीं आर्यन
I
जी
was
सुमित जी
I
प्लीज
was
अनम्यूट
okay.
योरसेल्फ दैट तभी
Seems
वो
better.
क्लियरिटी आएगी, वो एक बार में एक
Finally,
ही
we
unmute
go
रहे.
to the question wherein we file an application before the ACMM and we move further. By the ACMM takes a cognizance of it. He basically quashes the particular prosecution proceedings and your job is done. Now, these are certain offenses which are नॉन कंपाउंडेबल. अभी तक तुमने कंपाउंडेबिलिटी की बात कर ली, लेकिन अब कुछ ऑफेंसेस को जनरली कैसे आइडेंटिफाई किया जाए कि ये कंपाउंडेबल होंगे या नहीं होंगे. फॉर एग्जांपल, इन फ्रंट ऑफ अ क्लाइंट एंड द क्लाइंट वांट्स टू गेट अ फंड्स कंपाउंडेड, देयर इज अ प्लेथोरा ऑफ ऑफेंसेस अंडर द कंपनीज एक्ट. सो कुछ चीजों के थ्रू यू कैन आइडेंटिफाई दैट विल दिस काइंड ऑफ अ नेचर ऑफ ऑफेंस बी कंपाउंडेड और नॉट. The primarily one being offenses wherein only imprisonment is prescribed. There's no fine, there's no penalty, there's no nothing. The court simply or the act simply states that the person or the officer in default is to go for imprisonment. Those offenses are non-compoundable in nature. इसके क्या क्या टाइप्स हैं? सबसे कॉमन टाइप जो है वो 447 है. A lot of the sections under the act state that a particular, for example, there's an offense under audit, for example. So the section states that the punishment shall be prescribed in the nature as prescribed by section 447. So rather than giving a separate punishment for its particular its deviance, it goes under the category of 447, that is a category of fraud. A fraud in a basic sense under the Companies Act is very similar to what the criminal law has. That you, being the person who has committed the default by either by intent, or you can say by other means, you have dishonestly had some gain and you've dishonestly caused somebody a wrongful loss. इस सिनारियो में अगर आपका केस फिट कर जाएगा बेसिस द प्रेसिडेंस, देन यू कैन प्रोसिक्यूट और यू विल बी प्रोसिक्यूटेड अंडर द फ्रॉड, दैट इज कैटेगरी ऑफ 447. इसमें एक कैटेगरी आती है जो एक ऑफेंस है जो स्टेट जो दैट इज इन टैंडम विद 447 और फ्रॉड, दैट इज मिस स्टेटमेंट ऑफ इन प्रोस्पेक्टस. बहुत सी कंपनीज कभी कभी मिसस्टेटमेंट्स जो दे देती हैं, दैट इज why they are basically prosecuted. Their officers in default are prosecuted with imprisonment itself. So those offenses do not come under the category of compoundability. Secondly, falsification of accounts, that is under 229. That is yet again a grievous charge against a particular auditor or for the company. Those offenses also do not stand in the category of compoundability. Then Section 8 violation, that is a charitable company violation, would also amount in the same manner of non-compoundability. अगर इनको एक जनरल जिस्ट दूं मैं आपको, if you want to just understand how compoundability and non-compoundability works. So any offense which is against the public interest or is against or basically puts across a serious mismanagement on the company, that would come under the category of non-compoundable offenses. जो ऑफेंसेस प्रोसीजरल हैं या लैक ऑफ डिलीजेंस की वजह से हो गए हैं या जिनके अंदर मिस स्टेटमेंट्स नॉनशलांटली हो गई हैं विदाउट एनी मिस इंटेंट और एन इंटेंट टू डिफ्रॉड गोइंग इन, those particular offenses will be compoundable in nature. As on date, even after the amendment of 2020, certain offenses, especially the category of 447 and 34 and 229, still are in the category of non-compoundable offenses. However, certain have been decriminalized and put under the category of compoundability. Now let's move to some case studies. I will just show you certain orders that we have got from the Honorable RDNR. So, Priyanka ma'am, are we supposed to take the questions right up ahead or maybe post it for the end of the session? It's not very long. It's just going to take another 10-15 minutes.
आर्यन जी एट द एंड ही ले लेते हैं, बेटर रहेगा, देन कंक्लूड, है ना?
Sure.
You show the order, NCLT order, I'll speak about it.
No problem. So, Kamaldeep Chavla ji, we'll take this question at the end of the session. I just need another 5 to 7 minutes to finish off. So you must be able to see a order in front of your screen. This is a compoundability order that we got from the regional director, Northern Region. So this was a matter that default was committed under section 129 of the Companies Act. In this particular sense, आप stages notice कर सकते हैं किस तरीके से RD is having a notice of what all has been done by the company. So the first paragraph clearly states that it is an application filed under section 441, for which a default was committed under section 129 of the Companies Act. Now, this is where he states, as per the application, the registrar of companies had sent a show cause notice dated so and so to the applicant stating that in the profit and loss account for the year ending 31st March 2015, the company has not bifurcated basic and diluted EPS on the face of P&L account. This is the same case as I was talking about in the previous particular session. यहाँ पे डाइल्यूटेड और ईपीएस का नहीं दिया, ऑल्दो कोई डिफरेंस था ही नहीं उन चीजों के अंदर, बिकॉज देयर वाज नो आउटस्टैंडिंग डिबेंचर्स, देयर वाज नो आउटस्टैंडिंग डेट, सो देयर कुड नॉट कम एनी अदर डिफरेंस इन दिस पर्टिकुलर सिनेरियो. The next paragraph states the Registrar of Companies Delhi has submitted his report by letter dated so and so, wherein it has been reported. Now, this is the fourth step, as we had made in the particular PPT, wherein application is also forwarded by the ROC along with its comments on the particular application. This is that particular para. The period of default is for the financial year 2014 to 15. No complaints prosecution initiated or pending against the company. It is one-time default. However, the same offense under section 292 read with AS 20 has also been made in the financial year 2015-16. Further, the company has made default good from the financial year 16-17 onwards for giving disclosures of EPS and profit and loss. This particular para is clearly telling what I was stating earlier. First of all, 3 साल का बेंचमार्क है. अगर आपका उन्होंने यहाँ पे क्लियरली स्टेट कर दिया कि फर्स्ट वन टाइम डिफॉल्ट है, मतलब इससे पहले और 3 साल से पहले भी कोई डिफॉल्ट नहीं हुआ है. Secondly, in the final gist of the para, they've stated further the company has made default good from financial year 16-17. That is, compounding कराने से पहले उन्होंने अपने डिफॉल्ट को ठीक कर दिया है. That is the only criteria wherein the RD will entertain this particular compounding application. Secondly, it takes a note of who person appeared for the applicants and what has been stated. Fifth para is the holding of the RD. Keeping in view the facts and circumstances of the case and considering the submissions made, I therefore, by the virtue of powers vested in me, hereby compound the offence subject to the payment of compounding fee of rupees 75,000 per applicant. Now, this fee, if I tell you, was imposed both on the company as well as the auditors. The directors. So this particular thing was 75,000 each has been placed, as you can see over here. Now, as we were talking about prior payment of the fee and then passing of the final order, this is the final order, wherein you can see, pursuant to this forum's directions dated 8th of September 2021, compounding fee has been paid on 24th of September 2021. ये आपका एक प्रिलिमिनरी ऑर्डर आया, उसके बाद आपने फी पे करी, उसके नीचे इन्होंने डिटेल्स डाली हुई हैं. इन द फाइनल पैरा दे कंक्लूड एंड कंपाउंड द ऑफेंस इन व्यू ऑफ द अफोरसेड. As per the compounding fee has been paid by the applicants, the aforementioned offence is hereby compounded in respect of the applicants only. Yeah.
So अब क्या मतलब है कि जो ये आ गया आपके पास ऑर्डर, अगर तो कंप्लेंट फाइल होगी है सर कोर्ट में, तो इस ऑर्डर को आप जस्ट आपको दिखा दो और आपका जो क्रिमिनल केस है वो वॉश हो जाएगा. और अगर कोई कंप्लेंट फाइल नहीं हुई है तो कंपाउंडिंग तो फिर भी आपको करानी पड़ेगी, बिकॉज द ऑफेंस वाज ऑलरेडी कमिटेड इन द फर्स्ट प्लेस. Now, this was about as Aaron was telling about, it was about the directors of the private limited company and company being a separate legal entity on the company also. अब हमारी क्या बात रही सर, ये उस वक्त जो कंसल्टेंट थे उन्होंने इनकी तो कंपाउंडिंग करवा ली, ऑडिटर साहब की नहीं करवाई। अब ऑडिटर को पीछे से नोटिस आने लग गया, कभी कोरोना था, कोविड था, कोई दिक्कत थी। फाइनली उन्होंने अभी रिसेंटली साल 2 साल पहले केस डाल दिया कोर्ट में, मेरे पास मैटर आ गया। So now we have to get the compounding done for the auditor also. Please understand the fact that the the company, for the company it was section 129 default committed under section 129 of the Companies Act. However, for the auditor it was section 143 subsection 2. To be very precise, talking about the fact whether in his opinion the financial statements comply with the accounting standards. मतलब एक अर्निंग पर शेयर थी, उसकी बेसिक और डाइल्यूटेड का बाइफर्केशन नहीं दिखाया। द ऑडिटर हैड टू गिव दैट काइंड ऑफ अ क्वालिफिकेशन, या जो भी मतलब एग्जैक्ट आपके लैंग्वेज में डिस्क्लेमर या क्वालिफिकेशन आप जो भी देते हैं ऑडिट रिपोर्ट में, वो मिस हो गया, वो नहीं दिया उन्होंने, इवन दो इट वाज हैविंग नो इम्पैक्ट। सो वी हैव नाउ फाइल्ड एन एप्लीकेशन, कंपाउंडिंग एप्लीकेशन ऑन बिहाफ ऑफ दैट ऑडिटर, and he has been charged under section 147. इसकी पेनल्टी 147 में 143 सबसेक्शन 2 की। He have filed a compounding application under section 441 stating कि कंपनी ने डिफॉल्ट गुम कर दिया है जी, अर्निंग पर शेयर उसमें जीरो थी, तो बेसिक डाइल्यूटेड होगी नहीं, और कभी भी पहले कुछ ऐसा ऑफेंस हुआ नहीं, किसी स्टेक होल्डर को कोई कोई इफेक्ट नहीं पड़ा है। सो दिस काइंड ऑफ सर्कमस्टांसेस कैन गो विच कैन हेल्प फॉर द फैक्ट ऑफ कंपाउंडिंग, और फर्दर कंपाउंडिंग तो हो ही जाएगा, कंपाउंडेबल ऑफेंस है, बट the fact is that sometimes the penalty gets reduced when they understand that it was something which was bona fide and it was not coupled with anything which was a mens rea or an intentional on the part of the auditor. So that is how it goes.
So here's another reference for another order that we had got. This is in the same manner, exactly same manner passed, but this is under a different section. This one under 90, section 96. That is a default for not committing it, company not committing its AGM under one financial year that had been stated. So it flows in the same format. The first para takes a note that what is this application under which section and for compoundability of which particular offense committed under which section. The second para again highlights that the applicants have stated that the company has had failed to hold its AGM within the stipulated time period for a financial year ending on 31st March 2017. As per the requirements of the section 96 of the Companies Act 2013, the company ought to have held its AGM by 27th of September 2017, but the same was held on 29th of September 2017. Now you guys can see over here, it's a very minor delay. 2 दिन का डिले है, लेकिन 2 दिन के डिले के पीछे भी दे पुल यू इनटू द कोर्ट. सो आरओसी sometimes can be really, really, really strict on you for such kind of offenses, or you can say delays, and the RD can come into this picture by compounding the offense, but still you need to pay whatever the fine is. Secondly, एक चीज आपने इन सारे के सारे इन दोनों ऑर्डर्स में आपने नोटिस की होगी, that is compoundability does not absolve you from the liability for that particular offense. It simply means that you are there. आपको वहां पे एक्सेप्ट करना पड़ता है इस ऑफेंस को कि जी मैंने ये ऑफेंस कमिट किया, अब मेरे कमिटल के बाद आई एम बेसिकली कटिंग अ सॉरी फिगर बिफोर यू, सो यू गिव मी सम मर्सी एंड हियर बाय आई पे द फाइन. So a compoundable offense will never absolve you from the liability for that offense. It will always come and it will always be thought as that you were guilty for that particular offense. Therefore, the government has basically taken a lighter note on you and imposed a lighter penalty. See,
If you want to argue the case, if you want to say no, I say that offense is not committed, then it is a matter of trial. फिर तो आप कंपाउंडिंग में आएंगे ही नहीं, फिर तो कोर्ट में आप चले जाओ, लिटिगेट कर लो उस केस को, फिर तो एविडेंस चलेगा, आपकी तरफ से कोई एक वकील साहब बोलेंगे, सामने से वकील साहब बोलेंगे, एंड इट विल बी मैटर विच विल बी सब जुडिस बिफोर द कोर्ट ऑफ लॉ. बट व्हेन यू आर गोइंग फॉर कंपाउंडिंग, तो आप बताएंगे कि ये ऐसे ऐसे हुआ था, एंड दिस आर द रीजंस गुड दैट आई मेड गुड, एंड यू प्लीज बी लिबरल अपॉन मी. दैट इज हाउ.
Cool. So the next aspect again tells about the same thing. The Registrar of Companies NCT of Delhi and Haryana has submitted its report, white letter dated so and so, wherein it was reported that now yet again the application was filed by with the ROC. The ROC took a note of it. ROC forwarded to the RD, wherein it also made its own comments. That is the report that we had mentioned earlier. These yet again take a note of the same things. The most important para here would be para 3 and 4, wherein para 3 is clearly stating no such offense has been compounded during the last 3 years. आपको एब्जॉल्व कर रहा है, आपको कैटेगरी में लाके रख रहा है कि आप 441 के अंदर कंपाउंडेबिलिटी में आ सकते हो. वन मोर नोट ओवर हेयर, जब आप एक आरडी के आगे हेयरिंग के लिए जा रहे हैं, तो ये आरडी का काम नहीं है कि वो आइडेंटिफाई करे कि क्या आपने ऑफेंस 3 साल में कभी किया या नहीं किया, क्या ये ऑफेंस कंपाउंडेबल है या नहीं है. दिस इज द ओनली रीजन, दिस इज द रेशियो व्हाई द एप्लीकेशन इज फाइल्ड विद द आरओसी, बिकॉज आरओसी इज लाइक अ टिक चेकर इन दिस, कि क्या ये कंपनी ने 3 साल में कोई ऑफेंस किया, नहीं, ओके नेक्स्ट स्टेप. क्या ये कंपनी का ऑफेंस कंपाउंडेबल है, कंपाउंडेबल है, ओके जी नेक्स्ट स्टेप. Then if it gets stuck somewhere, for example, लेट्स से कि उन्होंने वो ऑफेंस कंपाउंडेबल ही नहीं है बट एक एप्लीकेशन लगा दी, क्योंकि वो एप्लीकेशन लगी तो वहीं पे आरओसी आपकी कंप्लेन को रोक देगा एंड इट विल सेंड इट बैक टू यू. सो आरडी डज नॉट गेट ओवरली बर्डनड विद दिस पर्टिकुलर थिंग. इट इज बेसिकली रजिस्ट्रार, जैसे हाई कोर्ट में रजिस्ट्रार होता है, कोर्ट में रजिस्ट्रार होता है फॉर द जजेस, आरओसी इज द रजिस्ट्रार ओवर हियर फॉर द आरडी. The next para number 4, clearly states yet again, as it was there in the previous one as well, appear XYZ person appear on behalf of the applicants, confirms that the application was made only by 2 directors and not by the company, being struck off in the year 2021, and the applicants have been prosecuted by the ROC before the learned ACMM, PCSRE Delhi. Therefore, the applicants have requested for compounding of the instant offense, followed by withdrawal of the prosecution from the court, consequent upon payment of compounding fee. अब इस सिनारियो में यहाँ पे प्रोसिक्यूशन लॉन्च हो चुका था. इन द प्रीवियस केस स्टडी वी सॉ दैट द प्रोसिक्यूशन वाज नॉट लॉन्च्ड, इट वाज अबाउट टू बी लॉन्च्ड. Here the prosecution was launched and the company's directors had come before the RD for getting the offense compounded, taking that particular order, filing it before the ACMM and getting that particular prosecution closed. अब उसकी वजह क्या है? That they want to strike off the company. दिस इज वन ऑफ द वेरी इंपॉर्टेंट एस्पेक्ट्स विच वी ऑल प्रोफेशनल्स नो, दैट अगर एक कंपनी को शट डाउन भी करना होता है और स्ट्राइक ऑफ करवाना होता है, देन वी नीड टू गेट द पर्टिकुलर ऑफेंसेस, एनी पेंडिंग पेनल्टीज, एनी पेंडिंग फाइन्स अपॉन द कंपनी टू बी पेड. अगर वो नहीं होगा तो कंपनी क्लोज नहीं होगी, कंपनी चलती रहेगी. सो बहुत बार क्लाइंट्स इसी चीज को लेके आते हैं कि जी हमको एक कंपनी क्लोज करानी है, लेकिन हम जब कंपनी क्लोज करने जाते हैं तो चेक करते हैं कि ऑफेंसेस इतने निकले हुए उनके अगेंस्ट. सो दोज नीड टू बी क्लोज एंड दिस एटलीस्ट टेक्स अ पीरियड ऑफ येट अगेन 6 to 9 months. The next para is that this was the officer, the presenting officer. It talks about the officer that is representing the government, that is the ROC. The presenting officer, joint director, appeared so and so in the scenario, and he mentioned that the compounding fee has been paid and duly complied. उस चीज का नोट लेते हुए RD imposes a that fine is paid, that challan is added in the final order, and the order is compounded. This is the final order that one gets. Yes, so
Okay, so as he was just telling about this was about being the compoundable offenses. उसका क्या procedure होता है, ये कैसे होता है. Now talking about the graver offense of the punishment for fraud, which is 447 read with 448. 448 would be the punishment for false statement. Stating this, come to 27 last page. In this is a very important case of जयंत पिरामल of NCLT अहमदाबाद. अभी का सर ये बड़ा recent order है, जयंत पिरामल versus Registrar of Companies Ahmedabad. Very, very important order, I would say, even though it is coming from the adjudicating authority only, which is NCLT Ahmedabad, of September 2025. Now, what happened was, you come to page 27 of the PDF, not 30. So, इसमें क्या हुआ? इसमें it was considered to be an offense under section 447. However, the NCLT intervened in between and they said कि इसको हम 447, 448 मान ही नहीं रहे. जबकि ये it gives a picture, if you would, as your all professionals will understand, that अगर कुछ material departure हुआ है, it was a fit case for 447, 448, and it's a kind of a rare case in the corporate jurisprudence, I would say. उसको उन्होंने amount ही नहीं करा. Let me just read it. I just open it. I have opened it. They say I'll come to the previous page. I'm reading F. If you just expand it a little. Yeah, I think it is visible to everybody. So they say form number DIR 12 is attached with the petition at annexure G. This was a petition which was filed by the director of a company. We have gone through this form and the name of the petitioner does not appear on the form. Therefore, though the form had material particulars, declaration of Mr. Howe, I am not required to obtain the security clearance from the MHA, Government of India, under so and so rule before applying for DIN as false. But the petitioner did not know that it is false because वो तो involved नहीं था form की filing में. ऐसा उसने तभी लिख दिया था DIR 12 पे file करा था. Therefore, provisions of section 448 does not apply and therefore no punishment is made out. Meaning thereby the tribunal had exercised such kind of a jurisdiction, such kind of a power or authority, in which they said that it could not be a case of 447. They were lenient and liberal in the view. The next paragraph will make it more clear. Para G, the petitioner is a director in the company. The filing of the form having false information is at best a procedural lapse, attracting provision of so and so rule. Okay, provision, but it is not a contravention of 447 read with 448. They say the violation being technical and procedural in nature does not result in any monetary loss or unlawful gain, nor does it affect the public interest. So this is very important. Once you go there to defend your case, or as professionals, we guide our clients, we would say that whether any stakeholder is impacted, what is the unlawful gain to me? What is the kind of an intention which I had exercised, if at all, if to be charged under 447? This tribunal is therefore of the considered view that the offence is compoundable under section 441 of the Act. It is compoundable because it is not a case of 447, 448. And then if you go further, they have made a table in which they have given all these kind of issues, the scenarios in which they say that it is a one-time offense, the preceding issue of the 3 years, which we were just talking about. So this has been given. So they say, now going to J, going a little further, J. It says, however, since the default committed has been made good by the company in which the petitioner is the director, they have ensured the compliance of the provision. Therefore, by considering the facts, it can be said that the default committed was not intentional and steps were being taken for correcting the mistake. Hence, this tribunal takes a lenient view by compounding the offense and hereby direct only a matter of 1 lakh rupees vis-a-vis that it was a case in which it would have invited prosecution, imprisonment, punishment for falsity or fraud. So this was this one important case we just wanted to talk.
So these are certain of the case studies that we work upon with, and these are matters that come on regular basis. Compoundability एक ऐसी चीज हो चुकी है जो हर कोई एक्सरसाइज कर रहा है, especially after 2019 and 20. Therefore, for the same reason, we have given certain comparisons between what was the scenario prior to 2019 and 20's amendment and what has been the scenario consequent to that. So, if we talk about these amendments significantly decriminalize certain technical lapses that were there. क्योंकि जैसे सेक्शन 92 है, सेक्शन 137 है, 129 है, ये जो लैप्सेस हैं ये टेक्निकल है बहुत बार ऑडिटर की मिस्टेक की वजह से या फिर कंपनी के डायरेक्टर की मिस्टेक की वजह से. देयरफॉर दे decriminalize certain offenses and got them in the category of fine or penalty or fine or imprisonment, not just creating a significant error of just being imprisoned. Then shift from prosecution to penalty based framework. Now, if you recall, there was a distinction between fine and penalty. A fine is that is imposed by the RD, but the penalty is something that is adjudicated by the ROC on its level itself. So they moved to the penalty based framework wherein the ROC can entertain these particular cases on its own behest. The person do not need to approach the ACMM or the NCLT or the RD for that matter as well. Secondly, a large portion of offences move to in-house adjudication, penalty imposed by ROC, as I stated earlier, कि वो कोर्ट जाने की जगह उन ऑफेंसेस को आरओसी लेवल पे ही डील करना शुरू कर दी, because ROC is the first point of contact that a company or a professional like us has in such scenarios. Thirdly, जो ये इंक्रीज ऑफ थ्रेशोल्ड था from 5 lakh rupees to 25 lakh rupees of pecuniary jurisdiction for the RD was done in the 2019 and 20 amendment itself. So finally, after these particular changes, after 2019-20, the numbers have also changed drastically. And these are certain examples for that. Over 70% of defaults filed for compounding involve filing delays. These are this is a true fact. In fact, with us, I would say 80 to 85% of the matters that we deal with are with filing delays itself. These two cases that I showed you were for the filing delay itself, or for that matter, a misstatement in the particular P&L, that the first example we showed you. But the filing delay was just for 2 days, if you look at the particular scenario. Secondly, Section 137 and 92, as stated, constitutes nearly 50% of the compounding application. कि जी हमने क्लाइंट आएगा जी, हमने तो एजीएम नहीं कराई, भूल गए, पता ही नहीं था, काम करते रह गए। बहुत सी जो जिनको हम लाला कंपनीज बोलते हैं, मोस्ट ऑफ दोज कंपनीज हैव certain kind of these offenses. And then there is Section 137 as well, जिसके अंदर ऑडिटर का डिफॉल्ट हो गया कि जी हमने मिसस्टेटमेंट कर दी कोई छोटी सी, या कुछ एग्जिस्ट ही नहीं करता था, बट द एक्ट वांटेड और द रूल्स प्रिस्क्राइब्ड इट, we couldn't incorporate, so therefore that offense came into the picture. Then this has also reduced the NCLT's workload approximately by 30% post 2020 amendment. But to be very, very honest, this makes no good to NCLT. We do matters for mergers, we do matches for insolvency before the NCLT, and their workload has only increased. So even if imagine now having compoundability application before the NCLT as well, what would have been the scenario? And finally, this average disposal time by the RD has come down to 30 to 60 days. Now, you might have a doubt in your head that abhi to I was stating 6 to 9 months for getting an offense compounded, but the average time for disposal with the RD is 30 to 60 days. This particular thing has a caveat of before the RD only. मतलब एक बार अगर आपका मैटर आरडी आगे पहुंच गया, उन 3 महीनों के बाद जब वो एप्लीकेशन आरओसी के पास से भेजी गई, तो 30 से 60 दिन के अंदर 2 से 3 हेयरिंग में आपका मैटर निपट जाता है. फर्स्ट मैटर में आरडी टेक्स अ नोट ऑफ योर मैटर. इफ ही इज ओवरबर्डन ही पुट्स अ डेट. सेकेंडली ही हेयर्स इट, इम्पोजेस अ फाइन. आप वो पे करते हो, थर्ड हियरिंग में फाइन ऑर्डर पास हो जाता है.
Now, this depends upon the quality of the drafting consultant also, because if it is done very clearly and it's perhaps factually also a minor case, then it may get solved perhaps in 1 or 2 hearings also. He is well satisfied कि ठीक है, जो भी penalty उन्होंने 50,000 लाख 2 लाख रुपए जो भी लगानी है, it gets disposed of in the first hearing also at few times.
Yes, so finally, this has been the scenario with compounding. With this particular slide, I'll conclude and I'll put across certain concluding marks. First of all, it was done for ease of doing business and simplifying resolution of defaults, which has been the case and which has been definitely a testament in the scenario for MCA, which has proved to be true. Secondly, एक अच्छा suggestion आ रहा है recently by the ICSI, which Sumit sir only found out and he let me know. It is technically a kind of a लोक अदालत for such offenses. अब हम लोग के गाड़ियों के चालान होते हैं, हमको ये पता होता है 4 साल में पूरी 4 लोक अदालत हैं. उसमें से किसी में भी आपका अगर टोकन निकल गया, तो आपका 3,000 रुपए का चालान 500 रुपए में हो जाएगा, 10,000 रुपए का चालान 2,000 रुपए में हो जाएगा. Similar kind of a thing has also been proposed by the ICSI to the MCA. If I may just share that. Yes, here we go. So this order. So this is a November 2025. It is a very recent thing, 10th of November, as you can read. So this has been written by the ICSI to the MCA for organization of a company law and LLP law settlement scheme 2025. Now, mind you, this has not been a pioneer initiative by ICSI. They've given precedences that certain things have also been done like this in the past, wherein this yes, but if you refer to this particular para, if you refer to this para, the ministry has in the past taken commendable steps to address similar concerns through previously issued circulars by providing relief to stakeholders. These circulars have facilitated a fresh start through Company Law Settlement Scheme 2014, Companies Fresh Start Scheme 2020, and LLP Settlement Scheme 2020. Now, what this scheme technically is promulgating is कि एक विंडो खोली जाए, उस विंडो के अंदर जो भी ऑफेंसेस हैं उनको पे ऑफ करने का ऑप्शन दिया जाए, चाहे वो एलएलपी हो चाहे वो कंपनी हो, उनके लिए, और उसके अगेंस्ट प्रोसिक्यूशन से प्रोटेक्शन प्रोवाइड की जाए. दैट वंस यू गेट दैट पर्टिकुलर ऑफेंस कंपाउंडेड by or settled, I would rather say not compounded but settled in this scenario by that particular portal of the MCA, then you can basically protect yourself or your company from the prosecution which shall be launched by the ROC in case against you. So this is a good initiative. I would also like to have your remarks whether certain things should be pushed by the MC or not. But in my opinion, this is a very good thing, not just for the people on the company side, but for us professionals as well, because this yet again brings in more work. And this is a kind of a work that can definitely be done by a lot of professionals because there are multiple defaults and often directors postpone those defaults because penalties इतनी बड़ी होती है कि जी बाद में देख लेंगे, अभी चल रहा है ना काम, भी फाइलिंग हो रही है, अभी कर दो. So this is something that comes into my picture. Thank you so much for your time, everybody. I hope I didn't bore all of you on a India versus South Africa day. So have a good time. Thank you so much for your time.
Oh, of course, it was a wonderful session, Aryan sir. So, shall we take up the questions now?
Priyanka ma'am, yeah, you there, yeah.
Okay. Shall we take up the questions, sir?
Ma'am, you're not audible.
आपकी
मैं
म्यूट हो रखी है आई थिंक. प्रियंका आवाज आ रही है मेरी?
हाँ जी सर, मुझे तो आ गई है, मैं आई एम अनम्यूटेड.
आई थिंक आर्यन जी को और सुमित जी को आवाज. सुमित जी आवाज आ रही है मेरी?
Yeah, yeah. Audible, audible.
आर्यन जी को आवाज नहीं आ रही
Yes,
है आई
Sumit
थिंक.
ji. No, no, he's able to hear now.
सॉरी.
He's able to hear. Fine.
Okay.
ओके.
सुन
यस
पा रहे हैं जी,
प्रियंका.
सुन पा रहे हैं.
So, shall we take up the questions, sir?
यस यस.
Surely, ma'am, surely.
I think.
So, we have this question. At which stage of the process the compounding application is filed?
So this question is by Kamaldeep Chawla ji.
Yes.
अब वो म्यूट करना पड़ेगा and speakers as well. So at which stage of the process?
ईयरफोन निकाल देना.
To like more.
जैसे पहले कर रहे थे, जैसे पहले कर रहे थे ना.
Just give me a second. Yeah, there's some technical snag at my end. Just give me a second.
ईयरफोन निकाल
नो
देना.
प्रॉब्लम.
बस मैं वॉइस कर देता हूँ. मैं कर दूँ वॉइस.
Good. Now we're good to go.
Hmm.
Yeah. So am I audible, ma'am?
यस परफेक्ट.
सो कमलदीप जी इज आस्किंग कि किस स्टेज पे हम लोग कंपाउंडिंग एप्लीकेशन फाइल करते हैं. वो यही रहती है सर कि पहले वंस यू टॉक टू द क्लाइंट, यू मेक द फर्स्ट बोर्ड रेजोल्यूशन पास होना इज बेसिकली अ पेपर वर्क दैट वी डू. वंस वी डू दैट पेपर वर्क, मोस्ट इंपॉर्टेंटली आप कंपाउंडिंग एप्लीकेशन तब लगाओ जब आपने ये टिक मार्क्स अपने एंड पे देख लिए. पहला कि 3 साल से पहले आपका कोई ऑफेंस कंपाउंड नहीं हुआ कंपनी का. दूसरा कि उसने क्या वो कंपाउंडिंग फी जो है या उसके अगेंस्ट हैज ही पेड दैट पर्टिकुलर कंपाउंडिंग फी और नॉट. If that is being there, then you can file for an application with the ROC in this stage.
So basically it is as soon as possible. अब जितना जल्दी लगा सके. What happens is that if there is any kind of a notice which is received from the ROC और कोर्ट में अभी केस भी नहीं गया, तो आपको you don't have to wait for the case to be filed in the court of law. Obviously nobody would want that the case comes in the court of law. आपको पता चल गया कि so and so such kind of a notice has come from the ROC, you immediately should file the compounding application. Even if it is not filed, obviously the conditions which RN is saying should be met. And after that, if it goes to the court of law, don't wait for the summons also to come. That's the compounding order because that will again take 5-6 months. As we were just telling, the process will take time. And if at all, अगर summons आ गए हैं, notice issue हो गया है, तो आप just आप request कर दो कि Lord, I'll take some more time. We don't want trial or charges should not be framed against me. We are going for compounding. Try to take a longer date or take an adjournment. And in the meanwhile, try to be expeditious about this process. ताकि आप compounding order लेकर ही सर के पास जाए कोर्ट में and then you get the caution done.
I hope Kamalji received his answer. So, shall we move to the next question, sir?
Please, ma'am. Yes.
So, a delay of 2 days in filing annual form, how they pick up these type of cases? Suo moto or against complaint? In fact, I also had this question in my mind.
Motto, okay. So this is difficult. This is more of an administrative process. It will be difficult to tell that. But obviously, these days, I would say the regulators are becoming very, very conscious, very aware in light of the fact that there are a lot of, with due regards, misfeasance also happening. So they want to see that if there is any kind of a contravention being made or anything, sometimes it is that somebody complains, a complaint reaches them, or it is also show motto. It could be also show motto that they know that this compliance has not been made good, which is why they send the notice across. So that is the long and short of it. It could be both ways.
So
So in fact,
participants,
अभी मेरे पास एक मैटर आया था जिसमें कॉस्ट ऑडिट का था. कॉस्ट ऑडिटर ने काम कर दिया था, डेट नहीं फाइल, कॉस्ट ऑडिट रिपोर्ट बना दी थी, पर जो उसकी फाइलिंग है वो रह गई थी. अब वो ऑडिटर भी डज नॉट वांट टू टेक दैट, कॉस्ट ऑडिटर डज नॉट वांट टू टेक द अकाउंटेबिलिटी. ही सेज कि आई हैव डन माय वर्क, मैंने तो साइन कर दिया. फाइलिंग बाद में हुई उसकी. सो उसमें भी देन आई वेंट टू दी कॉस्ट ऑडिट डिपार्टमेंट, फिर वहां जाके कंपाउंडिंग से ही हुआ था. प्रियंका जी, देयर वाज दिस वन क्वेश्चन ऑफ नरेश जी, but I think Naresh ji is here, so I'll just address that also. That
yeah,
was just I'll just take 2 minutes more if that is permissible, if I
of
may.
course, sir, of
All right,
course.
no problem. So he was asking कि जो अभी ये ADT 1 आया है जुलाई 2025 के बाद, if you can just take me to that question. In fact, वो थोड़ा सा ऊपर है नारंग जी के क्वेश्चन से ऊपर, I think. So he's saying that it is a new company which is formed, incorporated after 14 जुलाई 2025. जितना मैं अगर ठीक समझ पा रहा हूँ कि कंपनी 14 जुलाई के बाद बनी है, 2025 के बाद. तो जो कंपनी 14 जुलाई 2025 के बाद बनी है, तो सेक्शन 139 सबसेक्शन 6 में, इफ आई गो टू दैट, उसमें जो फर्स्ट ऑडिटर अपॉइंट होंगे, फॉर दैट यू नीड मैंडेटरी टू फाइल द एडीटी 1. So it says that the first auditor of a company shall be appointed by the board of directors within 30 days of registration. वो जो ऑडिटर अपॉइंट होएगा by the board of directors for this kind of a company which is incorporated after July 25, so they mandatorily now need to file that form ADT 1. और अगर बोर्ड फेल करेगा then the members will appoint within a period of 90 days. वो ADT 1 तब पहले भी फाइल करना पड़ता था, वो सेम रहेगा, वो अभी भी फाइल करना पड़ेगा. So I think Naresh ji's answer is also, question is also, I think,
Participants, shall we wait for a few more minutes? Are you asking the questions or shall we move on?
Priyanka, you can move on, already 7 o'clock plus. If
Okay,
there is any question, then take up. Otherwise, we will close the session.
okay, sir. So thank you so much, sir, for your valuable and practical session, a perfect conclusion to this week-long journey. With this, we formally conclude the refresher course on corporate law. A big thank you to all the speakers and to every participant for your active involvement throughout the week. We look forward to seeing you again in future CASA learning programs. Have a wonderful evening. Thank you.
And thank you to all participants. Thank you, Sumit ji, for your wonderful session along with the
thanks a
advocate
lot, sir.
Aditi. And
Thank you,
thanks
sir.
to all
I
participants
really,
who have spared your valuable time in last 1 week. Today also leaving the match. Yeah.
thank you to Team
So
CASA also,
thank
because I
you
attended
everyone.
some couple of other sessions also, and the quality of speakers and content
Sure.
and everything, timing was very good.
Yes.
So very good learning, sir. तो ऐसे
Thank
सेशन
you
आप कराते
everyone.
भी हैं
We
और
will
कराते
share
भी रहेंगे.
the presentation along with the recording, already shared 6 days. Seventh day recording will be shared and presentation will also be shared. Sumit ji, presentation आप मुझे mail कर दीजिएगा so
I'll
that
do
we
that.
can share with the participant. So thank you to each one of you. Thank you. Thank you, Sumit ji. Thank you.
Thank you,
Thank
sir.
you,
Thank you.
RNG.
All about
Thank you. Thank you, Prinka, for coordinating. Thank you.
Thank you, sir. Thank you.
Thank you.